So hello everybody and welcome to the first event of our last day of this incredible week. My name is Maria Lucia Casas and I'm part of the executive and editorial team of the Washington Arbitration Week. Today I have the great pleasure to introduce the moderator for this incredible panel, which is Lee Kaplan. Lee Kaplan is a partner of the International Arbitration and Dispute Resolution practice in the Washington, D.C. office of Aaron Fox. Lee acts as counsel of private and sovereign clients in a wide range of matters involving international dispute resolution, public international law, and international investment law and policy. Prior to joining Aaron Fox, Lee worked as a senior attorney advisor at the U.S. State Department's Office of the Legal Advisor, where he successfully defended the United States in various arbitrations. And with that, I leave you with Lee. Lee, you have the floor.
Thank you, Maria Lucia, for that introduction, and good morning to everyone. And I just second the welcome to the final day of Washington Arbitration Week, and would like to start by commending Jose Antonio and Ian on a truly excellent second annual conference. I know we've all thoroughly enjoyed this week's panel presentations, and we all thank you both very much for your truly Herculean efforts to make this conference a success. So our topic for discussion today is foreign investment laws. And what we'll be talking about are the domestic laws and regulations of a host state that, among other things, regulate and often protect foreign investment. Many of these, not all, but many of these also contain provisions providing for investor-state arbitration. So I think it's fair to say that foreign investment laws are the neglected stepchild of investor-state arbitration. We all know, we talk and write obsessively about the more than 3,000 investment treaties out there, but only rarely about the 72 foreign investment laws, many of which provide very similar substantive protections as investment treaties, and about 40 of which also contain investor-state arbitration provisions. And we know that we analyze every nook and cranny of the hundreds of treaty-based investor-state arbitrations and decisions, but there really is precious little commentary on the at least 70 arbitrations arising under foreign investment laws. So today, the neglected stepchild finally gets its moment in the spotlight, and we've dedicated the next hour and a half to a roundtable discussion solely on all things foreign investment laws. And we have with us today a truly exceptional group of panelists to guide our discussion. It is my real pleasure to introduce first Uche Anwamegbu. Uche is an international attorney at Aaron Fox. It's now Aaron Fox Schiff after the merger yesterday. He is an active arbitrator and arbitration practitioner. Previously, Uche worked as senior counsel and team leader at ICSID, managing over 70 cases in various economic sectors. And he's also served as legal counsel at the United Nations Compensation Commission. We have Jose Antonio Rivas, who needs no introduction. He's, of course, co-founder of Washington Arbitration Week, but also founding partner of X-Strategy, based in DC and Bogota, and chair of X-Strategy's arbitration and international law practice. He works in as an international counsel in investment disputes, serves as arbitrator, provides advice on public international law and investment law to sovereign clients, state-owned companies, and investors. And he's also a former ICSID counsel and foreign investment director of the Ministry of Trade of Colombia. We also have with us Jeremy Sharp. Jeremy is an independent arbitrator and practitioner based in Ottawa, Canada. He was previously a partner in Sherman and Sterling's international arbitration and public international law practices in London and Paris. And he has served as chief of investment arbitration in the Office of the Legal Advisor at the U.S. Department of State. He's also a private delegate on the U.S. delegation to UNCITRAL's Working Group 3, where he advises on a wide range of investor-state arbitration reforms. Also welcome Diana Tsutieva. She's counsel in Foley Hoag's International Litigation and Arbitration Department based in DC. She's dual qualified US-French international dispute resolution attorney with extensive experience in complex international investment arbitration matters, public international law matters, and international commercial arbitration. Diana regularly represents states, state-owned and private entities, and individuals in international disputes, including investor-state arbitration and maritime and land boundary disputes. She advises states on a wide range of public international law issues as well. So welcome to all of our esteemed panelists. Now, before we get started, I did want to provide a note of explanation. We have expanded the scope of our discussion considerably. When we began preparing for the discussion, today's discussion, we realized there's simply too much to talk about, so we've added a few topics. We're still going to provide a fresh look on consent to arbitration under foreign investment laws as advertised. That's a fascinating topic. But we're also going to explore trends in foreign investment law and practice and dispute resolution under foreign investment laws. And we'll consider also the various challenges of textual interpretation under foreign investment laws, and finally delve into some very interesting questions of applicable law under foreign investment laws. After our discussion, we'll have a 15-minute question and answer session. So I encourage everyone to send their questions through the chat function as we progress through the discussion. And then I understand we'll be automatically diverted into breakout rooms at the very end. So with that, I will give the floor to Uche to start our discussion about trends in foreign investment law practice.
Thank you very much, Lee. It's a real honor and a pleasure, of course, to be on the panel with such a distinguished group. My task in the next few minutes is to provide an overview on the basis of which the more detailed discussions will follow. And to do that, I'm going to touch on three main areas. One is the way these laws relate in the context of industrialized nations and countries in the other stages of industrialization. The second is foreign investment laws and investor-state arbitration. And then thirdly, a look at the cases or the numbers of such cases. Turning first to foreign investment laws in countries in different stages of industrialization, the first thing to note is that such laws or the existence of such laws cuts across high, medium, and low income countries, but they're more prevalent in low income countries. Now, there are 185 such laws listed on the UNCTAD database, and only 18 of them are laws enacted by industrialized countries. Now, there's also a regulation by the European Union establishing a framework for the screening of foreign direct investment into the Union. And this kind of sets the stage for the next topic, which is the fact that although there's such a proliferation across the board in different countries, the huge difference is that with the industrialized countries, the focus is on screening of foreign investments, while the laws in the low and middle income countries focus more on attracting and promoting investments. And in that regard, they offer incentives of the types that we are used to seeing in investment treaties, including access or consent to investor-state arbitration. And that takes us to the second point, which is foreign investment laws and investor-state arbitration. Now, again, from the publicly available information, about 74 of the national laws that we looked at reference investor-state arbitration. And out of that number, 42 of them actually provide consent. So the other ones refer to it without providing consent. Looking at publicly available information again, all of the laws that provide consent to investor-state arbitration are laws of low and medium income countries. And some scholars have been digging into this to figure out why that is the case. And some have suggested that developing countries are significantly more likely to consent to arbitration in their national laws after they receive advice from the World Bank's Foreign Investment Advisory Service unit. Now, the figures that were cranked suggest that such advice actually increases by 650% the chances of a developing country including consent to investor-state arbitration in its domestic law. The same research also found that governments with more experience, either having faced investor-state arbitration in the past or the ones that have ratified a lot of investment treaties, are less likely to have consent to investor-state arbitration in their national laws. And a number of countries are also now, with their experience, amending their laws to remove such consent. So looking at the cases themselves, the data out there suggests that cases founded on foreign investment laws reveal a curious pattern. Most of these cases either failed on jurisdiction or were settled or discontinued. Looking at the ICSID website alone, just the ICSID website, there are about 60, roughly 70, something between 68 and 70 cases that allege a breach of investment law. But it should also be noted that these cases involve, or some of them involve allegation of breaches of other instruments, such as contracts or treaties. There were 31 countries involved in those cases. One is a conciliation case, and 4 are under the additional facility rules. About 53, 55 of them have been concluded. And looking at the ones on which information is available, and for this, we had to turn to the ITL law website, 14 of them failed on jurisdictional grounds. 7 were settled or discontinued, and this is from a population of 29 cases. 2 were dismissed on the merit, 4 succeeded, and 2 are still pending. These figures would suggest, therefore, that it is more difficult to prove investment and investor status under foreign investment laws than under investment treaties, because there's quite a big disconnect here when we look at the figures coming out of investment treaties. And so to conclude this very quick overview, it's safe to say that while consent to arbitration in investment laws may be a popular feature or more popular feature in the laws of developing countries or countries in lower and middle income countries, it appears that those governments, while they have included those provisions, may not have actually fared that badly based on the information that's publicly available. And hopefully my co-panelists from their presentations will be able to throw more light on why that is the case. Thank you.
Thanks very much, Uche. Let's turn it over to Jose Antonio for some comments and reactions.
Thank you very much, Uche. What I've been tasked to do is to take a step backward and try to analyze the background under public international law of one of the notions that underlies investment laws, and that is that they are unilateral acts. So for a very quick overview, I'll just put up a few slides and share them with you.
Jose Antonio, just one moment. We're just going to take some reactions first to Uche's presentation, and then if you have some, feel free. If not, we can move to Jeremy.
Okay. No, I do have one reaction, which is whether any of the and that's a question more to Uche, whether he has a notion of whether the the lesser number of investment laws being a basis for consent in investment arbitration is somehow connected also to an issue of language in the actual provisions that are included in the investment laws.
Sorry, I didn't quite get that. The language in the
whether it's is it simply that is it your perception that the issue is more of a higher standard for investment laws, or is it more an issue of them not necessarily, or most of them not necessarily being drafted as to really giving consent to arbitration?
Well, like I said, it's only in about half of the 70 odd legislations in which arbitration is mentioned at all is there clearly consent. The rest of them, it's either non-existent or it's unclear. But quite at least a good number of them do contain the relevant provisions. What would I think what would be interesting to find out is where the provisions are that clear. How come the chances of the investor's success is still not that high compared to the numbers we see out of investment treaty cases?
And can I ask one more question? When you say success, you mean success that the tribunal will declare that it has jurisdiction, correct?
A success is relative.
Well, that's what I'm asking.
At the end of the day, it's a question of who goes home with a check in their pockets. It's a low bar.
Okay. Oh, okay.
Thank you, Jeremy. Anything to add?
Thanks, Lee. I do have a question that's somewhat stemming from Jose Antonio's point, Uche, which is are these figures somehow masking the real risk? Because as you mentioned, often you see in these cases a foreign investment law and another instrument that might provide consent to jurisdiction, for instance, a contract or an international investment agreement. And is it possible that we're seeing tribunals relying on the instrument, perhaps that they know, that are drafted more clearly to provide consent? And so we haven't seen as much attention to the foreign investment law. But now that we're seeing states perhaps tightening up their foreign investment contracts or revisiting their international investment agreements, perhaps adding more conditions to consent, or even eliminating some of the substantive obligations, we'll see more attention paid to these foreign investment laws. And that actually we'll find that there was this inherent or latent risk all along. It's just that we didn't see it manifested in these cases because there was an alternative route for the tribunal perhaps to find jurisdiction or to rule for a party on the merits.
You're absolutely right, Jeremy. It's difficult to tell. It's difficult to kind of tease out all the different permutations that this could take. But it's also interesting that some of these cases do not end up being resolved. A lot of them are settled or discontinued. It's also it could also be the fact that here you're dealing with an instrument that is put out there by the other side alone in the dispute, as opposed to where you are dealing with instruments that have been negotiated on by at least two parties or multiple parties. And I think Jose Antonio might be saying a little bit more on that whole thing about the unilateral consent, but there's no doubt that it gives the author incredible power as to what they are able to put out. And at least one would hope that by the time anybody sits down to draft these laws and put them out there, that they thought carefully about what they're exposing themselves to.
Great, thanks.
Very good. Thank you all. Diana, any reactions or comments to that?
Hello, everyone. Yes, perhaps an observation, Uche. So I think that what we've been seeing is that the states are revising the investment laws, maybe not at the same rate as that they're trying to revise their international treaties. And we've seen kind of like a range of different approaches. Years ago, South Africa switched to mediation in its investment law. And in terms of more recent revised investment laws, we've seen states again being careful about open the doors to in ISDS and instead saying, okay, we may agree to it either through a direct agreement or through another treaty. So certainly the states are being cautious about just opening the door immediately. But the point about getting advice on from the World Bank Agency on the best practice is quite interesting. And I query whether the fact that they're using 2010 investment law reform handbook is also potentially an issue, and it needs to be revisited since we're now in 2021.
Good point. It was, I think, interesting to some of us looking at the data. There were some studies in 2018 that had a much lower number of arbitration cases arising under foreign investment laws than today. The numbers have almost doubled. I don't know if that's there's a lot more activity going on under these laws, or we're just now compiling the data in a better, more comprehensive way, but it's an interesting trend to watch. Okay, thank you all for that. We're going to move to our next round of discussion. And now, Jose Antonio, we're going to begin our discussion with you about consent to arbitration under foreign investment laws.
Thank you, Lee. And thank you for the comments of Uche and everyone. One of the motivations for proposing this panel is that in practice, it's quite usual that the investment arbitration lawyer, as a part of the due diligence that they do whenever they meet an investor, they ask the obvious questions. Is there a contract, right? Is there an investment contract? And then the next question, of course, is there a BIT? But sometimes in that due diligence process, it is seldom done or thought of that they will necessarily go into a run of analyzing or searching the national laws and see whether there is a consent to arbitration in an investment law. And I've been surprised in the sense that some countries do have investment laws, and some of them do have investment arbitration consent in there. So that was one of the motivations to move forward with this topic. My task here is to take a step back and put in the terms that Lee introduced them. Investor state arbitration is sort of the child of public international law, and therefore there is something to be said in terms of where investment laws come when we put the framework of public international law and shine it in investment laws. So I'll share my presentation here. Just give me 1 second. Is it showing?
Yes.
Excellent. So now the very basic perspective will be one of public international law, and there we ask the questions: what are unilateral acts? And this has been in part defined by institutes and by the guiding principles applicable to unilateral declarations by the ILC in 2006. One can say that they are a formal declaration formulated by a state with the intent to produce obligations under international law. So there is a formal declaration. If you compare that to investment laws, clearly what more formal than an act of Congress or of the legislative? Then here, the guiding principles provide that the declarations publicly made and manifesting the will to be bound may have the effect of creating legal obligations. When the conditions for this are met, the binding character of such declarations is based on good faith. Interested states may then take them into consideration and rely on them. So we have several elements here to unpack. One is that there must be an intent to create a legal obligation, and then the ultimate principle here is, which is also a general principle of law under Article 38 of the ICJ statute, is the principle of good faith. Then we, what was it? Was the ILC that creative? No, it was not. In 1974, the main paradigmatic case in terms of unilateral acts, the ICJ stated in paragraph 49 of the nuclear test cases, New Zealand and Australia versus France. One of the basic principles governing the creation and performance of legal obligations, whatever their source, is the principle of good faith. Then it goes on and it emphasizes that just as the very rule of pacta sunt servanda in the law of treaties is based on good faith, so also is the binding character of an international obligation assumed by unilateral declaration. What's so interesting about unilateral declarations is that when you look into the Article 38 of the ICJ statute, you have treaties, you have custom, you have general principles of law. As a subsidiary source, you have also statements by the publicists and international judicial decisions, but you don't have a reference to unilateral declarations. However, considering that it is based on good faith, we can then conclude that it can also be a source of international law. Now, or at least I can. But the nuclear test cases were not the first ones that referred to unilateral declarations. And there's a very interesting, and doing a little bit of research here, there's a very interesting case, which is the Eastern Greenland case, in which Norway had said for many years that it did not consider Eastern Greenland part of its territory, and then at some stage it started occupying it, and of course, and I am being a little bit lax with the facts, but in any event, that's the gist of it. So basically, Denmark said, well, you made these declarations that you wouldn't be claiming that it's your territory. So what's now? And the court basically at the time, the PCIJ, not the ICJ, said that it considered beyond all disputes that a reply of this nature, basically the declaration of the Minister of Norway by the Minister for Foreign Affairs on behalf of his government in response to a request by the representative of a foreign power regarding a question falling within his province is binding upon the country to which the minister belongs. So there are some earlier cases that would ultimately help to constitute this as a general principle of law or even a customary rule of international law. Now, what are the requirements for those unilateral acts to be valid? First, there must be capacity of the state and persons authorized to formulate the unilateral declaration. Second, there should be a form for that unilateral declaration, but that form in itself need not to be necessarily in written form. Hence, when we think in terms of investment laws, the fact that they're written, the fact that they have been enacted by Congress or the legislative give it more force. And who was it addressed to? Of course, if it may be said that it is addressed to the citizens of the state, but of course, it is a clear signal and it's publicly made, and it can be, of course, relied upon by foreign investors as well. Now, how do you interpret those, which is the most difficult element here? Much has been said about the interpretation, and part of the interpretation under public international law is based on what the court has said with respect to declarations with regard to reservations to treaties. Some of those can be taken into account, and much of the case law of the ICJ comes from there, but not all. So when we look into the guiding principles, one of the elements that has to be interpreted is the content and the factual circumstances in which they were made, and of course the reactions to those statements. So when you think in terms of investment laws, one has to think, well, did they rely upon it? Was it in place still? Was the request for arbitration made while the law was in force, or was it withdrawn just a few days before the request of arbitration was submitted? Then I will only say with regard to interpretation that that it is important, at least under ICJ law, that the declaration must be intended to produce certain effects. And those effects must be in line with existing law. And that comes really from the case and passage over Indian territory. Now, one central question here is when can the unilateral act be considered null and void, and what is the duration of the unilateral act? When can it be withdrawn? And this is a key question because, of course, as a unilateral act or an investment law may be a unilateral act, Congress can simply withdraw and modify it. So here, certain elements must be taken into account. One, any specific terms of the declaration relating to revocation, so if the law has any duration. Two, the extent to which those to whom the obligations are owed have relied on such obligations. Three, the extent to which there has been a fundamental change in the circumstances, rebus sic stantibus, the principle. Those elements, and certainly the first two ones, are very important. Who relied upon the declaration? Who acted based on those declarations? And in our case, under the investment laws. Importantly, one case which may be one of the most familiar ICJ cases, the military and paramilitary activities in and against Nicaragua. In the jurisdictional decision, the court basically explained how the principle of good faith and relying upon the declaration, and in our case, or in the case of this session, in the investment law, relying upon that creates certain obligations of longevity with respect to the effects of the declaration. So the state that has given the declaration or the investment law in our case would not be simply entitled to withdraw that declaration at any time. Paragraph 59 provides that the unilateral nature of declaration does not signify that the state making the declaration is free to amend their scope and contents of its solemn commitment as it pleases. So there's no complete reign as to when to withdraw the declaration, because they have provided in good faith an expectation to the other states and members of the international community, in our case, the investors. Now, in paragraph 63, the court says the right of immediate termination of declarations with indefinite duration is far from established. So it's not forever. It appears from the requirements of good faith that they should be treated by analogy according to the law of treaties, which requires a reasonable time for withdrawal from termination of treaties that contain no provision regarding the duration of their validity. So here the analysis is somehow more subjective in terms of, did it acted in good faith after giving the declaration? And that would be, at least in my view, an extremely factual analysis. I think that that I have more to say, Lee, but I think that the main objective of my remarks was to provide a background on public international law. I do have some statements to make with respect to investment laws and some that have been declared by investment tribunals to be in fact reflective of consent, and some that have not, but I will leave that for later. Thank you.
Thank you very much, Jose Antonio. Very comprehensive and interesting. Over now to Jeremy for any reactions.
Thank you, Lee, and thank you, Jose Antonio. It's very interesting what you said. If we think about the foreign investment law as a unilateral act under public international law, if a tribunal, for instance, in looking at the termination of the act, might look to all circumstances, including potentially any reliance by a foreign investor, because foreign investment laws, as I understand it, weren't considered expressly by the ILC, it opens up a lot of questions, including, is every foreign investor that invests in a state in which there is a foreign investment law relying on that foreign investment law's dispute settlement provisions, such that if a state were to terminate that law, there could be some detrimental reliance that could be relied on. For instance, imagine a notice of intent to bring a claim being submitted under a foreign investment law, and then the state terminating the foreign investment law before the investor actually accepts any unilateral offer to bring a claim. So practitioners might then invoke the foreign investment law in its notice of intent as having relied on it in making the investment and bringing the claim. So 2 questions: any advice for practitioners? And second, do you think states are aware of this when they are drafting foreign investment laws, that there may be limitations on the ability of the state to terminate this after, excuse me. Sorry, the state aware of this and understanding the risks of adopting a foreign investment law, given that they may bind their ability to terminate the law at any time, given that in the normal course, the legislature or the relevant authorities may think that they're able to terminate any law after it's outlived its utility. Thank you.
Thank you, Jeremy, for that. I love the question because it's very similar to a few cases that have taken place at the ICJ, including the Nicaragua case in which consent to the ICJ jurisdiction was withdrawn a few days before the claim was submitted, but also in other cases that has taken place. To your question, I seriously don't think that the states that draft these laws are necessarily aware of the public international law limitations that if considered unilateral acts under public international law, they would have simply to withdraw. But I have to make a caveat on that. I believe that it may be easier for a government, for instance, to withdraw the consent to the ICJ jurisdiction than it may be for a state simply to amend a law or to terminate a law, because there's also, well, I would say it depends on the state, but in both a Republican democracy or in a parliamentary democracy, there are procedures to withdraw laws, and it's not that easy at least time-wise. It may be very easy in terms of will, but there are procedures that need to be followed. So it cannot happen just from one day to the other. Therefore, the investors should be aware of what is going on in Congress or in Parliament in order to be able to submit their request for arbitration in a timely fashion. Yeah, that's sort of my view, but I don't think that most of Congresses or parliaments, when enacting these laws, are aware of the ICJ jurisprudence and the case law. I don't think that that's the case.
Thank you guys. So now over to Diana and then to Uche for follow-up comments.
Sure. Perhaps one comment and a question for practitioners to consider is, what are the sort of the implications of the good faith interpretation? We've seen this approach, of course, with tribunals interpreting the arbitration clauses in the treaties themselves, where they say the interpretations from the objective standpoint in good faith as opposed to restrictive, which a lot of times states argue that consent is such an extraordinary step for the states that restrictive interpretation is appropriate. So I queried to which extent, practically speaking, the approach that you've laid out is sort of similar in how we approach in general interpreting arbitration clauses in investment arbitration.
Thank you, Diana. Also, thank you for that question, because it allows me to explain something that I did not. I think that if anything, investment laws as an instrument or as a basis for consent can be very much compared to BITs or to investment chapters in free trade agreements. They are somehow dissimilar from contracts. In a contract, you have, in the same instrument, you have the expression of the will of both parties in the same instrument. So that's not where we are. In a BIT, you have the offer from the state on the one hand to the investors, and then in the request for arbitration, you have the acceptance of that offer, and those two wills meet, and that's what crystallizes the consent of the parties to investment arbitration. Similarly, in the investment law, you can have the offer of investment arbitration, but at that stage, we have not identified who is the investor who will accept that offer. And then at a later stage in the request for arbitration, you have the investor accepting that offer, which is provided in the investment law, and then those two wills meet, and that crystallizes the consent to arbitration by both parties.
Yeah, just to add to that, Jose Antonio, I guess my question, I've got two questions, perhaps they could be comments as well. The first is, it seems to me that a lot of what's been described so far can apply to different types of legislations. It's not necessarily to foreign investment laws alone, unless I missed a nuance there. And then secondly, and more generally, do you consider that there is any difference in, for lack of a better word, the quality of rights and obligations arising out of these laws as compared to the ones that we typically would see in bilateral or multilateral instruments?
Thank you, Uche. So I think that you made two questions there. So one, the first one, or statement that this may also apply beyond investment laws, and I think that's absolutely right. Unilateral acts under public international, they can even be declarations by state officials, by the head of state, by the president, by the foreign minister, by the minister of economy, and so on. I don't think that the limitation is of it being a unilateral act is provided by public international law. In fact, the requirements were there, and there's no limitation as to it having to be an investment law itself. What determines the limitations are, in our case, the ICSID convention. The ICSID convention requires that consent be provided in writing. It requires that there be, at least in ICSID case law, a reference to ICSID. So the limitations are really provided by the applicable rules of arbitration or by the BITs themselves. Sorry, not by the BITs, but by the applicable rules of arbitration. Because in this world we're not under BITs now. To the second question, is there a difference in quality when we compared investment laws and investment treaties? The answer to that question would require doing a specific analysis of the laws. I've seen investment laws that are almost word by word exactly drafted as an investment treaty or as a BIT.
No, but beyond the text, when it comes to the application, when it comes to what's received on the other side, would you, as an investor, be assuming even if the text were to be word for word, do you think that there is a difference in the level of protection or the quality of protection simply by the fact that one comes out of a unilateral act and the other one comes from a bilateral or multilateral?
No, I do not. I don't think that, and the basis to say that I do not really comes from I would say from general basic public international law. There's no hierarchy in the sources of international law. I mean, there's no first son and second son. I mean, there's no first customary international law and then treaty law. They're equally situated. If some rights are provided by an investment law and those rights were born out of the consent of two parties internationally, the state has to respect them.
So if that's the case, why is it relevant then if one is a unilateral act and the other one is born out of a multilateral or bilateral actions? I mean, why doesn't the inquiry stop right at the point where we establish that rights and obligations have arisen?
I think that it's relevant for practical reasons. I mean, as counsel, of course, when you have submitted claims relying on investment laws, you have to tell your tribunal where those obligations come from. So otherwise, when they ask your source, they won't believe you. But for purely practical reasons. But I don't think that there's a hierarchy between the rights of obligations born out of one or the other.
Thank you, guys. We're going to move on to our third topic, our third round. This is deals with the sometimes vexing issue of interpretation under foreign investment laws. And we'll give the floor to Jeremy to start our discussion.
Great. Thank you, Lee. Of course, one of the criticisms of the current investor-state dispute settlement is a lack of consistency. But one area in which there's perhaps perfect consistency is the rules of interpretation for international investment agreements. You'll see every tribunal apply, or at least purport to apply the relevant provisions of the Vienna Convention on the law of treaties, whether or not the treaty applies as between the two states parties, including as a matter of customary international law. But the situation is different with foreign investment laws, and there's no consistency that I can see in the way that tribunals approach the interpretation of foreign investment laws. You can see at least 4 approaches in some of the cases. First is silence. Some tribunals do not appear to give any indication about how they're approaching the interpretation of the text of the foreign investment law. And that may just be because it's very clear. For instance, in the TradeX case, the tribunal suggested that it was unambiguously clear that Albania had consented to jurisdiction in that case, and perhaps felt there was no need to provide greater indication of the interpretive rules it was using. By the same token, if you look at the ICSID versus El Salvador case, for some of the laws invoked by the claimants, the tribunal said it was obvious that these did not provide consent, and it was equally obvious that the foreign investment law of El Salvador did provide consent. So perhaps in those cases, there was no need to say anything further. You do see at least what appears to be one case where a tribunal has relied exclusively on domestic law, and that's in Petrobart versus Kyrgyzstan. But even there, the tribunal says, well, as pointed out by the parties, the Kyrgyzstan constitution incorporates principles of international law, which may have influenced the tribunal. The third, you could imagine international law applying exclusively to the interpretation. And you see at least one reference in CSOB versus the Slovak Republic, where the tribunal was interpreting a notice published by the MFA, not a foreign investment law, but a unilateral act. And the tribunal said the question whether the parties have effectively expressed their consent to ICSID jurisdiction is not to be answered by reference to national law. It is governed by international law. And then the fourth, and I think perhaps the most common approach, is a reference to domestic law and international law. And you see variations in the awards or decisions on this point. For instance, in SPP versus Egypt, the tribunal applied general principles of statutory interpretation, taking into account relevant rules of treaty interpretation under the Vienna Convention and principles of international law applicable to unilateral declarations. So this suggests that the general principles of statutory interpretation were perhaps the primary means, and that they could be supplemented by applicable international law. Now, if you contrast that with Ginvali versus Georgia, the tribunal said that if the national law of Georgia addressed the question of consent, then the tribunal must follow the national law guidance, but always subject to the ultimate governance of international law, which suggests that somehow international law might trump domestic law. So the question is, does this really matter in practice if the tribunals provide a rule of interpretation or how they go about it? And the award suggests not that much, at least from what you can glean from the awards. And perhaps there are several reasons for this. As the Mobile Tribunal observed, even when an arbitral tribunal indicates the interpretive approach it's using, it very often focuses on the text, the actual language of the foreign investment law, and doesn't go much beyond that oftentimes. A second reason, as David Karen pointed out, is that tribunals often have a somewhat liberal interpretation of instruments of consent in these foreign investment laws. So whichever approach is used might lead them to the same outcome. A third is that the text itself is going to be the guiding principle, but it's often difficult to figure out which approach is being used. Even if the tribunal indicates that they're applying domestic law and international law, it's difficult to say how this influenced the interpretation. So the problem is, we know that tribunals often rely on the text, but the text in many of these foreign investment laws is deemed to be vague, ambiguous, even contradictory in the investment law itself or with other instruments or other authorities under the state's laws. Why is that? I suppose there are a few different explanations. First, these foreign investment laws were often drafted on the basis of models or templates. As Uche was suggesting at the beginning, World Bank has provided some guidance, and the World Bank used to have a dispute resolution provision, a model dispute resolution provision for foreign investment laws. But it's easy to imagine that some of these provisions could get garbled in the legislative process, even if they were clear from the outset. The second point, which was already touched on, is that states didn't have a lot of experience with investor-state dispute settlement, perhaps at the time when they were drafting these foreign investment laws. And so they might not have been as attentive, or even if they were attentive, they might not have understood all the nuances or ramifications of some of the language that was used. And then a third point, which was touched on as well, is that international arbitral tribunals may not be in a very good position to understand legislative nuance in some of these laws, or there may be problems of translation that make it very difficult for a tribunal to interpret it in the way that the legislators thought they were drafting the text. And you can see this lack of clarity manifest itself in the cases in a few different ways. The first, obviously, in the scope of consent, but also in the temporal scope and in this relationship between the instrument, the foreign investment law, and other authorities within the state. So as noted, many of these laws are quite clear on their face. Consent is provided or consent is not provided to investment arbitration. But as Michele Potesta observed in an article when he surveyed all these laws, there's this vast gray area where it's simply not clear from the face of the text itself whether the state has consented or has not consented to investment arbitration. And here you really see tribunals struggling to make sense of some of these laws. For instance, an example is the Penwell versus the Kyrgyz Republic decision, just came out a couple of months ago. The 2003 Kyrgyz Investment Act provided that investment disputes shall be settled by courts unless one of the parties asks or requests the dispute to be considered in accordance with ICSID or UNCITRAL rules. And the state said, well, if the investor has to ask, that implies consent, and consent is not given in advance. And the tribunal said, no, they looked at the text, they looked at the context, and they concluded that further consent was not required. But this just goes to show that the Kyrgyz Republic may have had one expectation about the application of its law, and in fact said, we amended our previous law, which we felt or was deemed to be not clear, in order to make consent not provided in advance. And still, whatever their efforts, they were not deemed successful by this particular tribunal. The second example is the temporal scope, and you can see this again in a very recent case, the June 2021 award in 000 Manoleum Processing versus Belarus, and the claimant had initiated an UNCITRAL arbitration under the state's 2014 investment law, and the question was whether that law applied to investments made or even disputes arising before the law came into force. Very interestingly, in this case, at least from my experience in having reviewed these awards, is that the tribunal did defer to the state's reasonable interpretation of the state's own law, which we don't often see, at least not expressly stated in an award or decision. The tribunal looked to the purpose of the act in the preamble, a kind of VCLT type analysis saying that the purpose included attracting investments, which did not seem to include the protection of pre-existing investments or pre-existing disputes. And then the tribunal looked to the definition of investment, which referred to property being invested in the home state or in the state of Belarus. So in the end, the tribunal concluded that this fell outside the temporal scope and there was no jurisdiction. You can imagine from the investor's perspective, this was not very satisfactory. The other authors in the literature that had looked at this law had deemed that there had been consent given in advance. And so it just goes to suggest that the lack of clarity creates risks and problems for states and investors as well. The third example I'll give is the ambiguity that arises in the relationship between the foreign investment law itself and the other legal authorities of the state. And one example we can look to is the Société Resort Company versus Ivory Coast, a 2017 decision, where the Ivorian investment law provided for ICSID arbitration, but it required the claimant to expressly consent to ICSID arbitration in its initial application for approval of the investment. That's the way the Ivory Coast interpreted their own investment law. But the claimant said that there did not need to be an acceptance of the consent in the initial application, that this could be made in the notice of request. And here the tribunal in part looked to the Ivory Coast's own model application for investment and noted that there was no provision in there about dispute resolution or accepting ICSID consent, and seemed to use this against the state to find jurisdiction in this case, which suggests to me at least that not only is there the problem of vagueness, indeterminacy, or lack of precision in the foreign investment law itself that can give rise to problems for foreign investors and states, but also a lack of consistency perhaps across the legal regime or the other legal instruments of that state that a state might need to look at to ensure that its foreign investment law operates the way that it had intended when it was adopted. So for me, just to conclude, the bottom line for the states is that these foreign investment laws often they're vague, imprecise, or even contradictory. And states are engaged in this process now of looking at the investor-state dispute settlement regime more holistically. In UNCITRAL Working Group 3, it's mostly focused on investment treaties, but perhaps this is a very good opportunity for states to step back, evaluate the priorities for investor-state dispute settlement and the protection and promotion of foreign investment, and look to see if their foreign investment laws actually reflect those priorities and are drafted in a way that gives clarity to investors and to future tribunals. Thanks, Lee.
Thank you very much, Jeremy. We'll go to Diana, Uche, and Jose Antonio for comments in that order.
Sure. Thank you, Lee, and thank you, Jeremy. One sort of maybe elaboration on the canons of interpretation that you talked about is we've seen particularly the ICSID tribunals alluding to the 2006 ILC guiding principles. And particularly what's interesting about those guiding principles is that they address the situation of ambiguity. And the provision there is that there's a rule of interpretation in the event that there is a doubt as to the scope of the obligations resulting from a unilateral declaration. It must be interpreted in a restrictive manner. But ICSID tribunals have found that this restrictive approach is not germane to ICSID arbitration, particularly because they found analogy and followed the approach of the ICJ in relation to interpretation of unilateral declarations, in particular optional declarations of compulsory jurisdiction of the ICJ. And what that means is that there is no restrictive approach, and that the offer in the investment law, the offer to arbitrate, must be interpreted as it stands, having regard to the words actually used, and that due consideration should be paid to the intention of the state having formulated such acts. And that can be deduced from the, as you alluded to, context, the circumstances of the preparation of the law, and the purposes intended to be served. And one issue there, of course, is we don't always have travaux préparatoires for those investment laws. And perhaps one of the things for the states to consider is documenting exactly what the intention is behind the investment law, particularly if the wording is not so clear and there is some doubt as to the scope of the offer made. And so we I wanted to highlight that this really raises also a strategic issue for council and how to approach this, because under the ILC guiding principles, there is a way to argue for a restrictive approach in the interpretation, but then under the good faith approach, it is arguable that the tribunals must examine whether foreign investors have formed any reasonable and legitimate expectations as to availability of ICSID remedies pursuant to a domestic law. So that is something that we've seen being debated in those cases.
Yeah, thank you. There does seem to be a bit of a tension. I understand that the ILC didn't address foreign investment laws as such in drafting their guidelines, but as you suggest, there's this restrictive principle reflected, which tribunals routinely dismiss from as far back as AMCO Asia. You don't look expansively or restrictively, but look at it under the terms of the Vienna Convention and so forth. So there could be this tension where tribunals might rely on the ILC guidelines in certain parts and ignore them in others, as you suggest.
Thank you, Jeremy. I'm just going to make the next comments optional, just given I'm looking at the time. But Uche, if you have something to say,
just a very quick one, Jeremy. You talked about lack of clarity of text and then lack of consistency in the approach to interpretation by the tribunals. The lack of approach. Is that something that you believe has been harmful to the system as well, or to the parties in general? And are both issues what you consider should be addressed by the or in the context of the reforms currently being discussed?
Yes, just very briefly, I do think all parties, the states and the investors, should know in advance what are the interpretive rules that will be applied to these instruments so that they can draft these instruments with some idea about how they'll be better interpreted. If tribunals are seen to be picking and choosing different aspects of the law to rely on to reach a result, it may be a fair result in the end, but it may leave one or the other parties very dissatisfied about this approach. For instance, looking to the preamble in one case, looking to another, an instrument outside of the foreign investment law in another case. There should be some better understanding of all the users of this system about the means for interpretation and how these are going to be applied in any particular case. Otherwise, I think we're just setting ourselves up for a lot of dissatisfied parties.
So that so far the issue is not that there's been massive instances of injustice happening, just that the uncertainty is not good for the system.
Well, in many cases, the state loses on this question. The state is interpreting its own law. Let's say the state is acting in good faith. That means the tribunal is interpreting the law in a way that the state had not intended. It's not like a bilateral investment treaty. This is the state's own unilateral act. And the tribunal is saying, no, your interpretation of your law is wrong. That's a problem for the system. If the states are acting in good faith, we should expect that the states are putting forth an interpretation that's consistent with how the law would be interpreted by courts of that state. In the main. Now, in any particular case, you may say they reached a reasonable result, but I would think we would want a result that's satisfactory for both parties, having looked at this issue in advance rather than in the heat of an arbitration case.
Thank you. Jose Antonio, yeah, quickly.
Very quickly. I want to sort of contest a little bit the notion that the good faith, let's call it the good faith doctrine based on public international law would necessarily lead to a more liberal interpretation or a less restrictive one. In particular, the nuclear test cases indicate in paragraph 47 the following, and I quote, when states make statements by which their freedom of action is to be limited, a restrictive interpretation is called for. So it is not necessarily quite correct that if we follow a unilateral act under the basis of public international law and ICJ jurisprudence, we would end up saying that the interpretation must be non-restrictive. And then just a question, and I believe that Diana may touch upon in her remarks later on that. What do we mean by a restrictive interpretation? Because in my world, if we apply the Vienna Convention on the Law of Treaties, Article 31, and if we apply the four means of interpretation, the meaning of the terms, and then the context and the purpose, all of them interpreted in good faith, then we end up in what I would say is a restrictive enough interpretation if we extend that and we say that those are customary means of interpretation, regardless of whether we're talking about treaties or unilateral acts, that applied to the text of the investment law should lead us to a restrictive enough interpretation. So I want to ask what do we mean by that? And I embrace all the comments made by Jeremy in the sense that, yes, we have to understand what context was it given, but also we have to look into the words that are included in the text. A good example of this, and you might touch upon this in your remarks, Diana, is what is the whole discussion about the investment law in Venezuela. That's a good example because there were several commentators that for many years opined in OJIMIT that this gave consent, and at the end of it, 3 cases, investment arbitration tribunal said no. I mean, it's not clear. So I think that the bar is not that low. There needs to be clear consent by the state based on the words. But I'll stop there, and perhaps Jeremy or might have some remarks.
Lee, perhaps we could just go to Diana, and then we could come back to it at the end if we have time.
That would be great. So we're going to move to our 4th topic of discussion. We told you we had a lot to talk about. We're going to move to the really interesting and sometimes equally vexing issue of applicable law under foreign investment laws. And what we'll do, just to make sure we have enough time for this segment, we'll go all the way to 10:30, and then we'll deal with Q&A probably in the chat rooms. So Diana, take it away.
Sure, thank you, Lee. And I will touch upon the restrictive interpretation later, but before this, I will indeed segue into the subtopic of applicable law as it relates to the sort of substance of the claims. So where the investment protections invoked by an investor are based on foreign investment law, the applicable law in principle includes at least the terms of that law and relevant domestic legal regime. And some of the investment laws state that international law also applies as a relevant source of law. But in most cases, what law applies and what is the precise content of that law has been disputed by the parties, often using experts on both sides to address that. So taking into account that the 2 main regimes for investment arbitrations, the ICSID Convention on the one hand and the UNCITRAL rules, it's helpful to frame the discussion in terms of the applicable rules under those 2 regimes. So under the ICSID Convention, the starting point, the locus of the rule is, of course, Article 42.1, which requires an ICSID tribunal first to see if there's an agreement between the parties as to the applicable law, and we refer to it as a choice of law provision. In the absence of such an agreement, the tribunal must apply the domestic law, and this is by the wording of Article 42.1. But in addition to the domestic law of the host state, the tribunal must apply such rules of international law as may be applicable to the parties' dispute. So giving tribunals some discretion on what rules it deems to be applicable to a particular dispute. So recent ICSID tribunals have applied this rule with some consistency. And in several of those cases, the respondent state used the applicable law to limit or even eliminate some of the claims that were brought by investors. And just to highlight a few of those cases, I want to talk about PACRIM versus El Salvador. And this decision came out in 2016. The tribunal found that the Salvadoran law at issue did not contain a choice of law provision. And so in the absence of such a choice of law, it held that it must apply Salvadoran law as well as the rules of international law as may be applicable. And based on that, the tribunal rejected the respondent state claim that the tribunal did not have jurisdiction over some of the claims brought by investor, specifically relying on principles of international law and customary international law. And the tribunal also emphasized the corrective function of international law in relation to domestic law. And in particular, it accepted, looking back at the older cases, it accepted the ICSID tribunal's holding that in order to invoke the arbitration jurisdiction provided in the investment law, there must be a claim with substantive grounds in that law. But such an approach cannot exclude applicable rules of international law in the absence of a choice of law. So again, very much adhering to Article 42.1 of the ICSID Convention. And more recently in the Interocean versus Nigeria, I hope I'm pronouncing the investor's name correctly, from 2020, which resulted in a victory for Nigeria, but on the issue of sort of like which law applies to the substance of the claims, the respondent state sought to dismiss the claim based on indirect expropriation, arguing that it's a claim under customary international law and not under the Nigerian investment law. The tribunal rejected this contention that an indirect expropriation and protection afforded under customary international law are excluded from the protection offered in the Nigerian investment law. It rejected the argument that the tribunal lacks jurisdiction based on customary international law because it found that, and this is important, that the language in the Nigerian investment law was drafted broadly and included claims under customary international law. It also highlighted that customary international law is part of the English common law, and that common law has been incorporated into the Nigerian law. So I think that's an important inquiry for tribunals to go into in order to justify admitting claims that go beyond domestic law. And so because the customary international law became part of Nigerian law, it was found to be applicable to the dispute. Under the UNCITRAL rules, and I'm moving now to a slightly different procedural framework, our Article 33 of the 1976 version of the UNCITRAL rules and the revised 2020-2013 rules have a similar provision. In any way, it differs slightly from the ICSID rule in that the parties can designate the entire legal system as the law governing the dispute. It provides that the arbitral tribunal shall apply the law designated by the parties as applicable to the substance of the dispute, but failing such designation, the arbitral tribunal shall apply the law determined by the conflicts of laws that it considers to be applicable. So arguably this gives more discretion to UNCITRAL tribunals. In terms of how this played out more recently, since we're also focusing on recent developments, I'll refer to the case that Jeremy, you mentioned, Penwell versus Kyrgyz Republic, which addressed the 2003 investment law of the Kyrgyz Republic. And, the starting point, of course, was the provision of the Kyrgyz law itself, which did not refer to international law explicitly. And the provision stated that the legislation that governs the regime is the constitution of the Kyrgyz Republic, the investment law itself, and other normative acts of the Republic. So the tribunal considered that to the extent that some international law principles that protect foreign investors form constituent part of the Kyrgyz legal system, that would be relevant for the resolution of the dispute, that the tribunal actually had the duty to apply them, and independently of how Kyrgyz courts would have approached this. And I found that very interesting, because what the Kyrgyz Republic demonstrated through use of experts is how these issues would be approached by Kyrgyz courts. But clearly the tribunal found that that was not controlling, and it held that while international law per se has no role to play in the present arbitration, the universally recognized principles and norms of international law would be applicable. And so, and precisely because it found that they form part of the Kyrgyz legal system. And so that's how it played out in the recent answer trial case. So to summarize and sort of open the floor for further comments from my co-panelists, based on the case law to date, what's emerging is that in deciding what weight to give to international law, the parties should bear in mind that tribunals will take into account factors which include, first, whether the tribunal is constituted under the ICSID Convention. And there we have to take into account Article 42, which makes specific reference to international law, or is it governed by another regime, for example, the UNCITRAL law? And ultimately, I think in practice, the arguments are similar. Another factor is whether the investment law contains a choice of law provision to the exclusion of any other laws. That would be obviously relevant for an ICSID arbitration. Whether the investor or investment should be considered foreign, and that is basically based on the terms of the law itself, and absent any guidance provided in the law itself, based on the tribunal's analysis of the ownership structure of the investment, the identity of the owners of the investment, the source of investment capital, and whether the investor or the investment were recognized as foreign by the state. And that's just to list a few of those factors. And finally, how international law is reflected or incorporated into the legal framework of the host state is going to be very important, as I alluded to a number of cases now that focused on that very much. So with this, I invite my co-panelists to provide further observations on the applicable law and perhaps your experience dealing with this issue in cases.
Thank you very much, Diana. We'll turn to Uche, Jose Antonio, and then Jeremy for comments in that order, if any comments.
I think I hogged the mic a lot already, so I'll cede my time to the others and come back at the end if there's still time.
Yeah, and same for me. I'll give my time to Jeremy if he has questions.
Thank you, Diana, for that very interesting presentation. I was just, as you were speaking, I was thinking perhaps this is another area where it really behooves states to look at their foreign investment laws in light of the applicable law, the flexibility reflected in Article 3 of the UNCITRAL rules, as well as in Article 42.1 of the ICSID Convention. And perhaps you know whether there's a trend toward reflecting the applicable law in the foreign investment laws, but it is a minimum, I think, yet another issue that states should focus on when they're turning an eye to their foreign investment laws in the context of broader reform efforts of the system.
Jeremy, I couldn't agree more. And I think that, and I find, just as I was reviewing the cases, what the importance of experts in these debates and explaining, how the legal system of a particular state functions. And of course, the state knows its law and should take that into account when implementing foreign investment laws.
Thank you.
Thank you. Any other comments, Uche or Jose Antonio? Got 3 minutes.
Perhaps, Lee, I could just maybe briefly come back to the restrictive approach, which was, I suppose it's something that would also be relevant to the sort of interpreting the scope of legal obligations and the substance of those investment laws as well. I think the way, Jose Antonio, I see it as being relevant, in practice, is when we're dealing with ambiguous language, and whether there is actually an offer made by the state to arbitrate. I think that we, from the perspective of the states, and I'll start with that and I will address another perspective. From the perspective of the states, consent to arbitration is an extraordinary concession. So, that approach that in the case of an ambiguous text, if there's an offer, somehow it should be in favor of investor, especially if the investor can demonstrate legitimate expectations, can be problematic in that it expands what the states they offering. And so in that sense, restrictive approach would go against liberal interpretation and prevent sort of construing that text as indeed offering consent to arbitration. From the investor's perspective, that is something that they would have to argue, right, and see if they can establish clearly legitimate expectations, whether the state itself intended to offer to arbitrate. And I think a lot of these issues play out through artful advocacy of experts and counsel.
Thank you. May I not, I'm raising my hand not in response to Diana. I agree with everything that she said. One of the reasons why I sort of kind of intimately react to the notion of restrictive interpretation is that it, at least psychologically in me, it creates this idea that it's overly restricted, but I don't think that there's also this notion that legitimate expectations would create some expectations regardless of the language of either the treaty or the investment law. And at least in my world, the expectations are only legitimate and reasonable when they really rely on what has been offered. So if what has been offered is not absolutely clear that it really provides an offer to investors at arbitration, the expectations are not reasonable and they're not legitimate. So I think that the notion of legitimate expectation has been inflated to the extent that the investor can ask for whatever they want, regardless of the language of the treaty or the investment, which is not true. When I want to make one last comment, which I think it may be important to share with everyone listening here, and we had this conversation during our preparatory meeting. One of the areas that has perhaps not been explored by states when they draft the investment laws is that, yes, there's this risk that taking an investment law from a model might be very risky, as we have seen and my co-panelists have indicated. But at the same time, if states were really informed about what they could include in those laws, that might be something interesting to explore, because they could include in those laws whatever requirements they wish to include, and without which consent to arbitration would not operate. So they could include statute of limitations. They could include waiver requirements. They could include consent to certain investors' obligations. And that area, at least to my knowledge, is unexplored territory. So on the one hand, yes, they have to be careful what they can include in those laws. But on the other hand, I have not seen a state really taking on the job of creating a law that would be specifically high in the requirements that an investor would have to meet in order to bring an investment arbitration claim. And that's food for thought.
Thank you, everyone. Well, it's a little bit after 10:30. This has been an incredible conversation, and clearly we could go on for another hour and a half or more. We'll have to save some of these topics for the third annual Washington Arbitration Week, if not sooner. But it is interesting to see foreign investment laws as perhaps still the neglected stepchild, but a really interesting and rich area, certainly fraught with complication and problems, but also with potentially a tremendous utility as a reform tool. And we'll have to talk about that in the breakout rooms and in subsequent conversations. There have been a few questions and answers. What I propose is I will circulate them to the panelists right now. And if you get lucky enough to be matched with the person asking the question in the breakout room, please take up the conversation or through some other means. I guess we'll just end it there and thank everyone. I give a virtual round of applause for our panelists who did a wonderful job, and we'll see you in the breakout rooms.
Thank you, Lee. Thank you, everyone.
Thank you, everyone.
Thank you, Lee. Now I'll be moving everybody to the breakout room, so please stay